Okay, it says we're live. It is still in the process of loading.
Well, on my screen, it says meeting is now streaming live, for what that's worth.
Yeah, we're live.
All right. I'd like to call the meeting, McCracken County Planning Commission to order. Let's all say the pledge of allegiance. Cue the flag.
There you go.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, under old business, if no one has any corrections or changes to the minutes, they will stand as emailed to us. Hearing none, we will do that. Do we have any conditional preliminary approval updates?
Still the Tiana estate sitting out there. We're either waiting on the paperwork for the roads or them to submit a new plan.
All right. Moving into new business. Do I have a motion?
I move that this commission receive and file the applications for the proposed subdivisions of properties filed by Walter and Nancy Rushing and Daniel and Jennifer Rushing, Kenneth and Patricia Trabuca, Michael and Judy Kaufman, Richard and Carmela Ballard, David Warford and Laura Grieve King, Richard and Julie Sangston, and Carrie Lee.
That one's pulled.
I think she's going to be removed. So.
Second.
All right. Thank you, Joe. Call roll, please.
Commissioner Hausman,
Aye.
Commissioner Metzger,
Aye.
Commissioner Young, Carol.
I think you must be muted. All right. She gave the hand signal.
I saw the hand up, and Chair Elliott.
You're still muted, Carol, for what that's worth. No, you're showing, you got to, yeah, all right. You're good now. All right, on the Rushing.
Okay. This one here, we saw a few months ago. Well, it's been more than a few months ago. The Rushings decided to give part of their property to their son. He is now selling the house, and the section they gave him that they want back. So if you can see where my cursor is, that line was previously abolished. We are reestablishing it. That's the only thing going on here. So this has been reviewed. Everything's appropriate in order. We recommend it be approved.
All right. Moving on to the next one, Trabuca. Cool.
Okay. On this one, there we go. Okay, so this is part of a large farm. They are cutting out 3 tracks there along Lovelesville Florence Station. There are 5-acre tracks. That's track 1, track 2, and track 3. Track 4 is going to be absorbed into the big farm tract that's located in behind this. And that farm tract has road frontage and an easement on Lovelesville Florence Station. Plus it fronts on the other side road. So this plat's been reviewed. Everything's in order and acceptable. We recommend it be approved.
All right. If no comments, we'll move on to Kaufman.
Okay. The next 2 plats are actually side by side. So this is out at Worth and Clinton Road, and the Kaufmans are splitting their property into track 2B1 and 2B2. They both have frontage on Clinton Road, proper size. This plat's been reviewed. Everything's in order and acceptable. We recommend it be approved.
If no questions or comments, we'll move on to the Grief King.
Now we got the Ballard first.
Oh, excuse me.
So on Ballard here, they are creating track 4 and abolishing the lines to create a larger track 5. And then you can see the Kaufman property to the east that we just dealt with. So everything's in order. We recommend this be approved.
All right, now moving on to Grief King.
Okay. Go. So this is a large farm, and down on Ogden Landing Road, they are cutting out a little over a 4.5 acre tract. They are creating, where my cursor is, they're creating that rear property line and abolishing the one where I'm at now to make that part of the 189 acre farm. So this plat's been reviewed, everything's in order and acceptable. We recommend it be approved.
If no comments, we'll move on to Sankston.
Okay, on Sankston, there's a lot between 2 here that's being abolished. We're creating a new property line here on the north, and here we're abolishing the one on the north and on the south and creating one in the middle to make 2 larger lots. So this plat's been reviewed, everything's in order and acceptable. We recommend it be approved.
All right, if no questions, we'll move on to Eads.
The Eads plat got pulled this morning.
Oh, yeah, that's right. All right, do I have a motion?
I move that the requested approval be given.
Do I have a second? Do we have a second?
I saw Joe's hand go up.
All right, Joe, you're muted.
Sorry about that. Second.
All right, call roll, please.
Commissioner Hausman,
Aye.
Commissioner Metzger,
Aye.
Commissioner Young, and Chair Elliott.
Aye. All right. Moving on to subdivision plats. Do I have a motion to open the public hearing?
I move to open the public hearing for Matthew 537 Property LLC, Richland Place preliminary subdivision plat for the property located on Wright Avenue and Echo Lane off Illinois Street that was advertised for March 24th, 2019.
Do I have a second?
Second.
Call roll, please.
Commissioner Hausman,
Greg, just real quick, is that date, March 24th, 2019, is that date correct?
that would be 2021.
I thought so. I
Yeah,
would like my motion to reflect that correction, sir.
yeah. That tells you how long it's been since a full subdivision has come through.
May have been prior to my time on the commission, so we probably ought to at least put 21 on there.
I've got it fixed on my notes.
Thank you.
Better that than 22. So, all right, call roll, please.
Commissioner Hausman,
Aye.
Commissioner Metzger,
Aye.
Commissioner Young, and Chair Elliott.
Aye. All right, Sightworks, would you like to present the subdivision plat?
Yeah, I'd be glad to. Some of you may be familiar with this project. It's kind of, it's formerly known as the Sarah Kitsanis Estates subdivision. And it was a subdivision or a piece of property that was part of the former city of Lone Oak when it was still incorporated. And there was a plat done for this subdivision back at that time. And it was recorded in the miscellaneous plat book as part of the city of Lone Oak. It did not come through McCracken County Planning Commission. So now that the city of Lone Oak has dissolved, we're basically just kind of doing a cleanup to get this property platted properly and bringing it to the planning commission to get that done so the current owner can develop the property further.
All right. Is there anyone who would like to speak in favor of the subdivision development?
Developer, Mr. Jones is, I believe he is on. He may want to speak if you have anything to add, Rick.
Well, hold on just one second. Mr. Cannon, do you have a staff report prepared?
Yes, sir. The required notice was mailed to adjoining property owners on March 9th, 2021, providing the date, time, and contact information to be able to take part in this virtual public hearing. On the same day, an ad ran in the Paducah Sun providing the same information. Copies of the letters, newspaper ad have been included in the record of this meeting. The subdivision originally began construction under the city of Lone Oak, but was not completed until after Lone Oak dissolved. Therefore, there was never any formal approval of the subdivision by either the city of Lone Oak or McCracken County. The subdivision is in existence and the roads have been in use. However, subdivision regulation 190.046 L1 states there shall be no private streets platted within a subdivision except as stated in 190.033B. 190.033B covers group housing, planned unit developments, office and business complex developments. These don't apply in this case since the subdivision has been developed, but because the roads have been built and in use, we don't feel that this should apply in this case. And because the roads have been tested and they have not been built to county spec. So we actually recommend that you all allow what they've got on their note on this plat, that this is a privately maintained public roadway that is not maintained by McCracken County. And that's simply because the roads are built, they are in place, they're currently being used, there's already duplexes out there. The city of Lone Oak did not have any setback requirements, and as such, the townhomes currently located in the subdivision only have a 15-foot front yard setback, and zoning ordinance 150.033B allows a reduction in front yard setbacks to the average depth of existing front yards. So it's our recommendation that you allow for the reduced setback for the remainder of the subdivision so that it remains consistent.
All right, thank you. Now,
Greg,
is there anyone who,
Are there other lots in that subdivision that have yet to be developed or built?
Yes. If let me zoom in on here. So if you notice, lots 11 and 12 have not been developed. Lots 1 and 2 have, so is 3 and 4, and 5 and 6. So 7 and 8, 9 and 10, 11 and 12, and then 15, 16, 14, and 13. Those are all still undeveloped.
Would future development be included in this setback?
Yes, that way it will create consistency among the subdivision. We don't do this often. We have done this twice. Once was when there was a commercial development in Lone Oak, and the surrounding buildings, they all were too close to the road. So we used this 150.033B to allow the new building to have the average setback there. We've also did that for Lake Forest for their Ridge Run phase, that they asked for a reduced setback so that it will match the rest of that subdivision, which had a reduced setback. So
They won't have to come back before the commission for those future lots.
no, these lots shown on the plat will receive that 15-foot setback if you all approve it, and that will be it. They won't have to come back in each time they want to build.
Good. Thank you.
Very good question. All right, does anyone like to speak in favor of the subdivision development? Hearing none, is there anyone who'd
Rick,
like to?
hey, Rick, you're on mute there. One second, Wayne.
All right, no problem, Jason.
Thank you, whoever told me I was muted. Mr. Chairman, I would like to say a couple of things. First of all,
Introduce yourself first.
oh, I'm
please.
sorry. My name is Rick Jones. I'm the basically the sole member of Matthew 537 property, the owner of the property. And all I want to say is I'm very appreciative of Mr. Cannon and McCracken County officials who've met with Mr. Goins and I and have worked through this, believe it or not, really very complicated situation. And I do appreciate that. And I'd appreciate it if you guys would accept this plat, let us record it, and let me sell this property off. Because right now, all I own is an unsubdivided tract of land. One big tract of land with 3 duplexes and some lots. But I will tell you, there's an HOA formed for the maintenance of the roadways since they're going to be private. And I think that it could be a nice development if we can go ahead and sell it into lots and let some buildings be built on those other lots. I appreciate your consideration.
Yeah, thank you, sir. Would anyone like to speak against the subdivision development? Hearing none, do I have a motion to close the public hearing?
I move to close the public hearing.
We have a second.
Second.
Call roll, please.
Commissioner Hausman,
Aye.
Commissioner Metzger,
Aye.
Commissioner Young, and Chair Elliott.
Aye. All right. Do we have any comments, questions, or do we have a motion?
I move to accept the preliminary subdivision plat for Matthew 537 Property LLC, Richland Place subdivision located on Wright Avenue and Echo Lane off Illinois Street.
Do I have a second? Thank you. Call roll, please, Mr. Cannon.
Well, was that Brent with the second?
Yes, sir.
Yes.
Commissioner Hausman,
Aye.
Commissioner Metzger,
Aye.
Commissioner Young, and Chair Elliott. Okay, Mr. Jones, I will let you know, this means that the preliminary is approved. The final will need to come back through next month or whenever you're ready for final approval. And at that point, it can get recorded. We don't have to do the public hearing process again.
Thank you.
All right. Do I have a motion to open the public hearing?
I move to open the public hearing for the Rudolph Holdings Company LLC parking waiver for the property located at 5199 Hinkleville Road that was advertised for March 24th. And Greg, if you'll change the date to 2021.
Yeah.
Do I have a second?
Second.
Call roll, please.
Commissioner Hausman,
Aye.
Commissioner Metzger,
Aye.
Commissioner Young, and Chair Elliott.
All right. Jason, I guess you're still with us. Would you like to present the parking waiver?
Sure, be glad to. This is a lot located at 5199 Hinkleville Road. It's right on the corner of Olivet Church Road and Highway 60. A lot of people don't even know this lot is there because of the size of it, but it's immediately to the west of the BB&T Bank. And the developer, current property owner, Bart Rudolph, is looking to utilize this space for food trucks. And so we have done a basic site plan showing a general arrangement of how those trucks might be situated on the site. But one of the issues that came up in talking to Greg about site plan approval, at one time we didn't even know we needed to get a site plan approval, but the parking situation came up, and Greg informed me we needed to show the parking situation. So that is why we come before you today in requesting a variance on the county's parking requirement for this particular usage. Currently food trucks are a new thing in the county and the city. The county is yet to even have an ordinance put forth on food trucks. I think that's something that may be in the works. So because of that, there's really not a good classification to go by on how many parking spaces are required. And working with Greg, the zoning ordinance says if there's no exact match to this particular use, then it's Greg's responsibility to pick something that is as close to that use as possible. So in this case, Greg informed us that they would go with a drive-through classification, which requires 8 parking spaces per window. So I think anybody can tell that's really not a very practical way to look at it. But given what the classifications are listed in the zoning ordinance, we have to pick one, and that's kind of what we have to work with. So because of that, that would require a total of 40 parking spaces on this lot. And there's just not room for that one. And really, there's really no need for that many vehicles to be on this lot at any given time. So we have shown an arrangement of approximately 21 parking spaces is what would fit given this arrangement. So with that being said, and going with the ordinance requirement of 40 parking spaces, we're actually asking for a waiver of 19 parking spaces. So it's kind of a unique deal, and just hope you guys would give us some latitude on what we can do there.
Jason, is there another classification that you would, I understand you're not concerned, I understand your issue or comment on drive-through and 8 spaces per window. Is there another classification that you would more liken this to?
To be honest, there's really not a good match at all. I mean,
Right.
The way it's broken down, it can either be a quick style restaurant.
Which would actually require more spaces.
Yes, and there's the drive-through, and then there's also a sit-down style, which is based on the number of seats in the restaurant. So it's just not a good match at all.
Right. So you're comfortable with the drive-through category selection, as long as the waiver could be granted?
Really not comfortable with any of the 3 options, but that one I guess is the closest it appears.
Okay.
Was that someone addressing us?
I assume the entrance is off of Olivet Church.
Correct. The shaded area there is an existing. There was an existing entrance apron that has been there for years, and we have gone on and submitted a new encroachment permit application with the State Highway Department to be able to finish out that entrance and connect the apron to this lot, and that's been approved by the State Highway Department.
Good, thank you.
Mr. Cannon, do you have a staff report prepared?
I do. The required notice was mailed to adjoining property owners on March 9th, 2021, providing the date, time, and contact information to be able to take part in this virtual public hearing On the same day, an ad ran in the Paducah Sun providing the same information. Copies of the letters and newspaper ad are available for your review and will be included in the records of this meeting. The property is currently zoned commercial. While a parking lot is a permitted use in a commercial zone, the specific use of a parking lot for mobile food vehicles is not. The McCracken County zoning ordinance does not currently have a parking requirement for mobile food vehicles. And as such, the ordinance charges the zoning administrator with making a determination of a similar use. As such, I chose a restaurant drive-through which calls for 8 stacked spots. While stacked spots are not necessary for mobile food vehicles, the nature of the business of a mobile food vehicle and drive-through are similar, and that's why I called for the 8 spots. Additionally, you have before you today a proposed text amendment to add mobile food vehicles to our zoning ordinance, and the proposal calls for 8 spots per mobile food vehicle if a mobile food vehicle is located on a standalone lot not associated with an existing business. It's the staff's recommendation this parking variance not be approved as presented.
All right.
Hey, Greg, my computer cut out as you were reading that last part. Can you repeat that?
Yeah, okay. You've got a proposal for a text amendment to our ordinance before you today that covers mobile food vehicles. And as part of that text amendment, we are recommending 8 spots per food vehicle if it's on a standalone lot that's not associated with an existing business.
Per vehicle or per vehicle or per window?
Well, per mobile food vehicle.
Okay.
So I guess if you had it, you could pull in a semi trailer set up as a mobile food vehicle. We didn't go quite that far. You know, typically you see the box truck style or something set up on a trailer that you pull behind a pickup.
I just want to make sure we have a clear understanding. You know, a lot of times food trailers will have an order window and a pickup window, or a pickup window on left side and right side. Earlier, Jason mentioned 8 parking spaces per window. I don't want somebody to move forward with this project and think it's 8 per vehicle and then show up on the lot and somebody say, oh, no, it wasn't 8 per vehicle, it was 8 per window.
Yeah, no, we've got it specified per vehicle.
Okay, thank you.
All right. Is there anyone who'd like to speak in favor of the parking waiver?
Art, are you still on there?
Yeah, I'm here. Sorry. Had to get, hang on a minute. Yes. Obviously, guys, I want it to pass. You know, it's.
Introduce yourself, sir, please.
My name's Bart Rudolph. I'm a sole member of Rudolph Holdings. I bought the lot with the intentions of doing this because it was my interpretation that it was just a lot, and there wouldn't be any disqualifications for any reason. So obviously, it's a financial burden to me because it's a lot that I thought that I could use it now that if this doesn't go through, it's not financially viable for me at all. And to be honest, we don't want more food trucks in there than there comes a point where if you get so many trucks in there that it's competition for every truck and it's not financially beneficial to them either. If you look at the lot, there's considerable space when you put the truck outside. What I would ask for is that we not look at this as a drive-through restaurant. You know, I've been a drive-through restaurant, and that's well, just to be honest, it's kind of an overkill. As you know, there are times a day that there's a lot of traffic in a restaurant. Typically, they just filter in and out. So if you could give this variant, be very much appreciative to you. Something in between where you're at, and maybe something that make it viable and worthwhile.
I want to add something too, guys, as far as speaking in favor of it. I just want to mention I've been involved with this property for several years, probably 10 years, in working with the previous property owner, Drew Walker, the Express Lube owner. And multiple times he's come to me with potential businesses wanting to, will this fit? Will this work? And to be honest, there's just multiple dead ends. It's only about a 11,000 square foot lot that building a structure there is just dang near impossible. It has to be something very, very small. And so when this idea came about, my initial, this is a slam dunk. Finally, something that will work. There's no structure. We don't have to deal with the restrictive building setbacks. I mean, this is a perfect fit. You can make the art. There's no ordinance at all right now for food trucks. No ordinance at all for how many parking spaces are required for a food truck. So I feel like we're kind of backed into it. Well, we got to pick something. Well, we got, when I first talked to Greg about what our options were, there was even talk that a site plan wouldn't even have to be submitted. When we got a little more information and determined there's going to be 4 to 5 trucks placed on here, that's when parking came about. The initial conversation was, well, how many do you think would be needed? I think the term or the number 3 to 4 parking spaces per truck was thrown out there, never 8. So to hear that the text amendment or the text for the new food truck ordinance is 8, I mean, that just seems like a lot personally. But the thing is, right now, there's no ordinance at all. So we're being kind of forced to pick a parking classification that really just doesn't match or apply. So I feel like there's got to be a little latitude or a little leeway knowing that there is no ordinance for food trucks, and they should have some latitude on what would be allowed there.
All right, thank you. Jason?
I'll add a comment there. This is Leslie Owen. Bart's asked me to research this, and this is something that I think several municipalities across the nation really struggle with, determining what the ordinances should look like for food truck type, where they can park, and what the parking lots look like around the food trucks. So I think what Bart is asking here is to, I think we're okay with the determination that it's a drive-through, even though it doesn't quite fit. But you're really asking for a variance from the requirements from the drive-through, separate from the text amendment that's been proposed. But it truly does not fit within a drive-through at this point. The drive-through anticipates that there will be cars lined up around the drive-through establishment. The food truck type business would be that people would park their vehicles, walk up to the food truck, order, walk away with their meal and drive away. They wouldn't be eating on site. So the 8 cars is not really necessary at any time. The other use that it may fit into is the quick style restaurant, which is also not really defined under the ordinance. And it calls to square footage for dining room, which there is no dining room. So it truly does not fit within anything that's in the ordinance currently. So I think, Greg's recommendation, let's slip it into the drive-through restaurant as appropriate. But variance is also appropriate in this case because the 8 spaces is just not necessary for the food trucks.
Is there anyone who'd like to speak against the parking waiver? Hearing none, do I have a motion to close the public hearing?
I move to close the public hearing.
Do I have a second?
Second.
Call roll, please.
Commissioner Hausman,
Aye.
Commissioner Metzger,
Aye.
Commissioner Young, and Chair Elliott.
Aye.
So, okay, at this point, I think we need to take a short break and let David work on some findings of fact for you all for this public hearing. David, how long do you think you'll need? You're muted.
I've been working on them as we've been sitting here discussing. Maybe a 5-minute break.
Be good for me.
Okay. We'll take a 5-minute break. I'll leave the meeting up, and David, just let us know when you're ready.
Thank you.
I know this is me, and it was me. I got email for the same call. Great, Shannon.
All right. This is David. I'm back. Can everyone hear me? Sure. So I've just been preparing some findings of fact based on what we've heard on this Rudolph request for variance. I'll read them to you. I've come up with 14 bullet points. Some of them are.
Excuse me, David, hold on just a second to Brent. Brent hadn't got back with us yet.
Oh, thank you.
Okay, here he
All right,
is.
he's present now. Go ahead, David.
Sure. And as I'm going through these are the ones that I wrote down that were important to my legal ears, at least. And if the commissioners have other points, please raise them. First of all, findings of fact that the public notice of the application in this hearing was appropriately advertised, which a copy of that advertisement's in the record. Number two, notice of the hearing was sent out appropriately. A copy of that notice is also in the record. Number three, the zoning map for McCracken County currently shows the zoning classification for this property is commercial. The subject property that we're dealing with is owned, as you all have heard, by Rudolph Holding Company, LLC. In the findings, I've included the size of the lot as 0.266 acres and the deed book and page number. This property is currently vacant. The applicant for this variance proposes to develop the subject property for the purposes of establishing 5 mobile food vehicles on the property. While a parking lot is permitted, is a permitted use in the commercial C zone, the specific use of a parking lot for mobile food vehicles is not. Additionally, the McCracken County zoning ordinance does not currently have any parking requirements for mobile food trucks. In the absence of a specific ordinance, the zoning administrator is tasked with, quote, making a determination of similar use. The planning and zoning administrator has made the determination that 8 spaces are needed for food trucks, and that's making a similar use under zoning ordinance 150.058. As currently proposed, 5 mobile food vehicles would need to be served by 40 parking spaces as determined by the zoning administrator. Mr. Jason Goins of SiteWorks presented the plan development on behalf of the entity requesting the variance. This is point number 10. The applicant is requesting a waiver of 19 parking spaces, which would be 4 and 4.2 spaces per mobile food truck vehicle, rather than the 8 as determined by the zoning administrator. Mr. Bart Rudolph appeared to testify in support of the variance and is the sole owner of Rudolph Holding Company, LLC. He purchased the property with the intent of developing the mobile food vehicle concept on this property. If the variance is not granted, Mr. Rudolph testified that it will make this project and his plans not financially viable. Mr. Jason Goins of SiteWorks also provided testimony regarding prior landowners of this lot and their efforts to develop it given its small size. According to Mr. Goins' testimony, granting the variance would allow the land to be developed. Ms. Leslie Owen, attorney representing Mr. Rudolph, appeared and described her efforts to look for similar circumstances for mobile food vehicles in different jurisdictions across the country. She offered testimony regarding why the 8 parking spot stacking requirement in section 150.058 does not match the reality of mobile food vehicles on this particular lot. Final point would be that no one appeared to testify in opposition of the application.
All right. Anyone have questions or comments?
Won't be there overnight.
Carol, we can't hear you.
Right now.
Carol, you're muted right now. Unmute yourself. You're going to have to click unmute on your computer. There you go. Oh, you're muted. You're muted again. Click something. All right, you're unmuted, Carol.
I was asking whether trucks be there.
I can't hear you, Carol.
I'm going to call her on my cell phone and put her on speakerphone.
Yeah, we need to hear what she has to say.
I think she's asking something in reference to the trucks being parked there overnight. Is that what you were saying?
Right.
Oh, good lip reader.
I got 4 kids, Wayne.
Hey, I've got you on speakerphone.
Okay, my question was,
Where's the
the hours the trucks will be there, would they be there overnight or just during the day?
Okay. Ms. Rudolph, you hear that question?
Yes, so the trucks would stay there.
Okay.
Probably
So they're probably more like a permanent station for them.
Well, it would be their spot. They would pay for that spot and then no one else would take it. So they'll take their trucks elsewhere. But they'll be able to come back and that spot will be vacant for them.
Okay. Thank you.
Thanks.
So it would need to be 5 trucks to make it viable.
5 trucks is, when we first started, I looked at it and thought 7 or 8 could be done. But then when you start looking at the size, we went to 6 and then to 5, and 5 is kind of the magic number, when you look at all the expense of the property and the development of it. It's going to take a while to get it back if we don't have 5.
Okay. Now, one thing you just mentioned was that the trucks would be potentially left there overnight, things like that. So if the trucks aren't moving, then that means you're going to have employee parking. So if you've only got 21 spots and 5 trucks, then you're essentially cutting your parking down to 16 spaces right off the bat. Is that not correct?
It's possible unless you can purchase some parking at Kohl's. Purchase a lease agreement with Kohl's or Chick-fil-A, which is what we had intentions of doing.
Okay, but that's not currently in place.
We have not, no.
The parking classifications take into account employees, though.
What'd you say, Jason?
The parking classifications in the zoning ordinance they take into account employees. We don't have to add additional separately from what the ordinance says because of employees. In other words, if 8's required, then it doesn't matter. You don't have to break out whether they're for employees or not.
Any other questions, comments, discussion? Do we have a motion?
Based on the finding of facts from our attorney, I move to accept the parking waiver for Rudolph Holdings Company LLC located at 5199 Hinkleville Road.
I did hear you correctly. You went with the move to accept, right, Brent? Right, Brent?
I move to accept.
Thank
Okay. You're moving to accept the findings of fact and the waiver, correct?
That is correct.
Okay.
All right, to make sure we're all on the same page, you're moving to go with possible 5 trucks there, 8 parking spots per truck?
No, the 4 spots.
Oh, yeah, but you're gonna waiver the 19, right?
The requested waiver was to waive the requirement of 19 spots
All right,
based on the size of the lot only permitting 21 parking spaces. So I move to accept the waiver of parking of the 19 spots.
all right, I was just making sure we were all understanding what we were getting ready to possibly vote on. Do we have a second?
Okay, Carol seconded it.
Carol got it.
All right. Call roll, please.
Commissioner Hausman,
Aye.
Commissioner Metzger,
Aye.
Commissioner Young, and Chair Elliott.
I assume Carol's was an aye.
It was.
All right, I'm not that good on sign language. All right, our next item of business is ordinance text amendment about such mobile food vehicles.
I move to open the public hearing for the proposed changes to the McCracken County zoning ordinance regarding 150.041 mobile food vehicles and 150.109 amendments and development plans that were advertised for March 24, 2021.
Do I have a second?
Second.
Call roll, Mr. Cannon, please.
Commissioner Hausman,
Aye.
Commissioner Metzger,
Aye.
Commissioner Young, and Chair Elliott.
Mr. Cannon, do you have a staff report?
Yeah, so we've got 2 different proposals before you. The first is for mobile food vehicles. And with mobile food vehicles, that will define what qualifies as a mobile food vehicle, where they're allowed to set up. The proposal says that they may only operate in commercial, light industry, and heavy industry zones. So that would keep a mobile food truck from setting up in a subdivision, something like that. There is an exception in there for things like ice cream trucks that don't stay for more than a few minutes at one location. Ice cream trucks isn't the only thing, but that's the first example that comes to mind on that. We've got parking requirements in there. Let's see here. The requirement of a mobile food permit. So if a truck's going to operate, then they will have to come and see me. We got to make sure they got all their paperwork in order. They've been approved by the state health department. They're registered with the county treasurer's office. And then the process for renewing the permit or revoking a permit if necessary. So all of that is laid out in there. There is a provision that prohibits noise They may not emit bells, music horns, or other audible noises used to attract customers. Strobe lights, flashing lights, or other repetitious lighting are prohibited. So we've got that in there. Does anybody have any questions? I mean, it's a 2-page ordinance by the time we got it. And I will say it is fairly similar to the city of Paducah's. Steve Irvin wrote the city of Paducah's, and Steve Doolittle and I worked with him to figure out, some of it just did not apply to the county. So that stuff was easy to remove. The rest of it, we talked with Steve to find out what was working, what wasn't working, and go from there, things that needed changing. So we think we've got something that's pretty solid, and I hate to say it, but we have the luxury of having used the city as a guinea pig, I guess, since it does so closely follow their ordinance.
So Greg, let me just get clarification on that. If I own a piece of property in the county, would this ordinance prohibit me from hiring a food truck to come to my farm or property to serve guests on my property? And if so, while you're thinking about that, if so, how is the difference? So I think you're on slippery slope there. So I can hire a caterer to come to my property, but I can't hire a truck.
Yeah. Well, now, if there's some sort of event going on, and I know one of the things where you frequently see that is auctions. A lot of times auctioneers will have a food truck show up and set up there. In a situation like that, that would probably end up being allowed. It's because you're talking about like a 2-hour period or so one time.
Well, and that's what I want to try to eliminate, Greg. I don't like the word probably.
Yeah.
I mean, it either is allowed or it isn't allowed. Is there a time frame that should be there? And maybe it's not an auction. Maybe Joe wants to throw me a 50th birthday party on his farm that, maybe he's got 6 or 8 acres and he wants to throw me a birthday party. And the cool hip thing is to have the taco food truck. But if this ordinance would not allow that, then I'm not sure we're going the right route.
Depending on the zone, I'm going to say it flat out, it wouldn't allow it because it would have to be in a commercial, light industry, or heavy industry zone.
So I can hire a caterer to come to my farm, do a fish fry, barbecue, stay all weekend, but I can't have a food truck come for an hour or two. That's where my problem is.
I agree.
Yeah.
That's my problem.
You bring up a very good point, Brent.
Okay.
We're in the business, if we're not careful, and I don't want to belabor the point and I don't want to be obstinate, but if we're not careful, we're in the business of picking winners and losers. Susie Q Catering Company is okay to do it, but Joe Bob's food truck can't. We've crossed the line somewhere, I think.
Yeah. Well, and part of the reasoning behind this though was because in the county, it's not like what you see in the city. In the city, you've got parking on the streets where a truck can pull over to the curb, set up, and it doesn't impede traffic in any way, shape, or form. And you're not going to have that out in the county. Now, you present an interesting scenario. You're talking about them coming off of the road, setting up on private property for an event. And,
and at the same time,
watch that though, because if you allow that, then if somebody's got, say the property next door to you was vacant and the person who owned it decided, okay, I'm going to just let a food truck set up there. And then you've got a food truck set up there in a residential neighborhood that's zoned urbanizing residential. And there's no recourse then at that point.
And I'm okay with a restriction as far as time frame. I'm not okay with a restriction saying they can't come. I mean, obviously, if a food truck is in operation, they've either been hired by somebody or they're going to somewhere where there's people. They're not going to come down my cul-de-sac and park in my cul-de-sac because there aren't customers there. There's not enough money there to make it worth their while, you know? So,
And you could also have a restriction of time and consecutive days, but I would want the availability to have a food truck come set up for a party or for anything that I was going to have, but that doesn't mean that I want one there for a month long. And I honestly, I mean, after sitting here and looking and listening to everything today, I question the 8 spots per truck. I think it's fine for one, but like what they're doing at what we just gave a variance for, I think that's a little strict.
I think the variance allowed it not to be so strict.
Mm-hmm.
Yeah.
I think that's
But if we pass this ordinance, then we've got it strict on everybody else.
Well, I mean, that would still follow any of the parking regulations. Somebody'd have to come back and request a variance on the parking, just like any other business. I mean, Menards did that when
Right.
it came through because they said that their study showed they did not need as many spots as what the ordinance called for, and they provided you with a parking study. The Lakes did this very same thing when they did their last edition. They came in and said, here's 3 other facilities we run. This is the number of parking spots we found we needed these. So this is what we're requesting. And you all are good about approving those variance requests, but you know, that's why that process is written into the ordinance.
Okay.
All right, Greg, if I was decided I was going to have my own little Woodstock this summer out on the farm, I don't want to have to ask the county if I can have food trucks come out for the weekend of my little music festival. If I want to park them out here in the field or whatever, not mess up the roads or whatever, I should be able to have as many as I want food trucks for a weekend. And I shouldn't be having to ask permission whether it's 1 or 10 food trucks on my farm for a festival.
Okay. So what are you all proposing as far as length of time, number of days, things like that? Because I don't think it can go without any regulation, because then we do run into the situation somebody's going to find a subdivision that's got good frontage somewhere and there's a vacant lot and somebody's going to park a food truck on it and neighbors are going to be squalling and we have no recourse.
What about
Well, I
2
would
days
think-
and any 7 consecutive days?
Yeah, I would think for a festival, 2 to 3 days or whatever. You know, if somebody wanted to have a festival.
Or Greg, could you do it something similar to that without prior approval? You know, if you want longer than 3 days, then it's got to have prior approval.
Yeah, well, then it's what you brought up earlier. We're picking winners and losers, because then you've got to come in and each case is judged individually, and that can get tricky too.
Sure.
You know, you want to take away as many of those possible issues. we're going to have some along the way. Okay. We will look this over and we will go through it and bring something back to you all then. But
I feel like that is the consensus of the commission is that we do not think we're limiting people's individual rights.
yeah. So we're going to have to do something because they're coming, either that or because we've got a permissive ordinance. Since food trucks aren't listed, the result's going to be they're not allowed to operate in McCracken County. So, you know, we're going to have to do something and do something fast. So, because they are growing. There's been quite a few pop up around here recently. So, okay, we'll work on something and bring something back to you. So, I've also got to work with the judge to see what the fiscal court. So, you know, it's not only what you all want, you know, the fiscal courts at the end of the day, they're the ones that has to approve it. So I've got 9 people I got to try to make happy.
Oh, well, I do think that we're probably representing the general public at large, pretty much as a whole. People don't want their rights to have a party or a festival or whatever limited by government.
Yeah. So
Greg, are you saying, did I hear you correctly, without this proposal, food trucks cannot operate in the county at all or on county property?
we have a permissive ordinance. So like when you go through and read your ordinance, if you look at agricultural or rural residential in any of the zones, it tells you what your permitted uses are, what can be done in those areas. And food trucks is not listed. So right now they could probably get in, they could get in a commercial zone because restaurants are a permitted use in a commercial zone. But right now, if they want to go set up at somebody's house for an event, it's not permitted. Because that is taking a commercial. Now, I know you mentioned the caterers, but caterers typically go inside and set up, and it's not out where all the neighbors see. That is a difference there. But we're going to have some work to do. So I'll work on it. I'll bring something back to you. This is also why I broke the motions for this up into individuals instead of one, as we did with the public hearing.
I'm thinking there is one consideration given to that.
Carol, I barely heard anything you said.
I'll call you and tell you what I said.
Okay. Okay. Are we ready to move on to the next one, the amendments and development plans?
What do we need to close this public hearing in?
No, because we're doing both of these under the same public hearing.
Okay.
So it's just your motions to approve, table, or deny are those are separated out.
All right. We'll move on to the next one then. So
Okay.
Are you going to read a staff report about that one then?
Yeah, I'm going to hit the high points on this. For the amendments and development plans, we strongly encourage you all to approve this one. This covers how when amendments and development plans apply, how they're handled, in what situations. And it covers things from public hearings and to also to handling amendments to development plans. Currently, we do not have an efficient process. If you all approve a development plan and somebody needs to make a change, we had one, AAA Stowaway. They come in, they got approved, and then right before they started construction, they realized there was a problem, and it was simply their building orientations, and they needed to change their build. Actually, the footprint shrunk slightly, not by much. They had to wait to come back in to go before you all to get that approved. This proposal gives the staff the ability, and it lays out when we can and when we can't. If it's what we define as a minor change, then that can be staff reviewed and approved. Changing the orientation of the building, not changing the use or the size, that would be considered a minor change. One of the things, originally the Planning Commission had the ability to hear a variance with a development plan. If we had not specifically written that in when we passed our parking ordinance a couple of years ago, you all would not have been able to hear that variance request earlier, because somehow over the years, your ability to handle a variance when it's presented with a development plan got removed, and it shouldn't have. That's very inefficient. That is counterproductive for development, because the way the section is currently written, somebody would have to bring a development plan to you. You all would have to approve it, and they would have to go to the Board of Adjustment for a variance. So it's quite possible you all could believe that a development was acceptable, but it then goes to the Board of Adjustment and they disagree with you and they think, well, it's acceptable, but they don't need this variance. That drags it out. It's at minimum a 2-month process. So the proposal here puts that back to you all and allows you to be able to grant variances when it's tied to a development plan. This section has a bigger impact on me and the way my office operates than just about any other section on here. So do you have any questions on this?
Any discussion whatsoever?
Greg, can you highlight what we're specifically proposing?
Okay, so it covers going down through here. It covers how you can do a variance or with a conditional use permit or with a development plan and zone change. You don't currently have that ability. You all took that away from yourself. Then it lays out what the requirements are for development plans when they're required. So you have to have a development plan if you're going to put multiple principal structures in an urbanizing residential zone. You've got to have a development plan if you've got a map amendment. And you've also got to have the development plan when you've got a subdivision like we had earlier. It defines what a sketch plan is, what a preliminary development plan, and what a final development plan. The preliminary is what you saw with the subdivision today. That did not receive final approval. It's still not recorded. It's still not official. It's your chance to review it and provide your feedback. You know, you all may have decided, no, it's not appropriate to give that 15-foot front yard setback. So between the preliminary and the final, they would have had to have gone back in and change their front yard setbacks. And then it lays out what has to be in it. So that's talking about showing the north point, your scale, the location and dimensions of the lots and any structures. It lays out the process for a map amendment. So that's getting the application into me, what we have to do to meet the state notice requirements, what they have to turn into us, the application, the development plan.
So the intention is not necessarily to be more restrictive, but to better define our process. Yes,
and to better to define and make more efficient.
Right.
That's the big part, is to make the whole process more efficient.
Sure.
Because we've got a lot of stuff in here. The only purpose it honestly serves is to slow development down. And it's stuff that can be eliminated and should be eliminated. The old section has been tinkered with many, many times because it didn't work. Somebody played with it initially, it got broke. And then everybody following has been trying to fix it. And the fix was the original plan, the original section. When I actually got my hands on the original section, I said, that's what we've been trying to do for the last 4 years. But it had been amended so many times that it had gotten so far away. Every time we tried to fix it, it wasn't working. And we didn't know, we couldn't figure out what, why, or how. And it was because some stuff had gotten deleted over the years that should not have been. And when I actually got to see the original text, it was a light bulb going off. This makes sense now. This is functional. This will operate in a timely manner. Everything we had been trying to do and couldn't figure out what to do. So this has actually been approved previously because it was the original section. And that's what we're asking for, is go back to the original that actually worked and functioned properly. And a lot of those tweaks were made by me, and it was trying to get to this point, and I just couldn't ever get it there. So a lot of these changes were before your time, Brent, but Wayne, Carol, and Joe have sat through all of them. I think we've lost count how many times I brought proposals through on this section, we get something done and it helped, but it didn't get us all the way to where we wanted to be.
I understand.
So.
That answer your question, Brent?
Yes, sir. Thank you.
Any other questions or comments?
Sure, Ellen, okay with you, I would feel more comfortable if we made the motions separately. We've got one open.
If you look at your packet, after we close the public hearing, I've got you. We've got a motion for the mobile food vehicles, and then we've got one for amendments and development plans.
Yeah, they're going to be voted.
I have learned to anticipate this when we bring multiple changes through at once. One public hearing, multiple motions.
All right. If nothing else, do I have a motion to close public hearing?
Do you need to favor? Somebody to speak in favor or against?
Oh, well, I guess if you want to get particular, all right. Does anyone like to speak in favor of the proposed changes? Would anyone like to speak against the proposed changes? Do I have a motion to close public hearing?
I move. to close the public hearing.
Okay, we got a motion from Carol.
All right, do I have a second?
Second.
Call roll, please.
Commissioner Hausman,
Aye.
Commissioner Metzger,
Aye.
Commissioner Young,
Aye.
and Chair Elliott.
Aye. All right.
Had to give it to Carol Brenton. It's the first time I heard her all day.
I had to switch text things. I don't know what happened. I had to go back to my phone.
All right. We're now going to have a motion on the first matter of the food trucks, where we have a choice to approve, deny, table. Do I have one of those three motions?
I move to table the proposed changes to the McCracken County zoning ordinance regarding mobile food vehicles until next month's meeting, April 28th, 2021.
Do I have a second?
Actually,
Call roll, please.
okay, Commissioner Hausman.
Aye.
Commissioner Metzger,
Aye.
Commissioner Young,
Aye.
and Chair Elliott.
Aye. All right. Now do we have a motion about the zoning ordinances and the last stuff we just discussed?
I move to approve the proposed changes to the McCracken County zoning ordinance regarding amendments and development plans and recommend the McCracken County Fiscal Court adopt these changes.
Do I have a second?
Second.
Call roll, please, Mr. Cannon.
Commissioner Hausman.
Aye.
Commissioner Metzger,
Aye.
Commissioner Young,
Aye.
and Chair Elliott.
Aye. Does anyone like to make a public comment? Hearing none, do I have a motion to pay the bills?
A motion that we pay the bills for $1,225. Mary Emerson.
Do I have a second?
Second.
Call roll, please.
Commissioner Hausman.
Aye.
Commissioner Metzger,
Aye.
Commissioner Young,
Aye.
and Chair Elliott.
Aye. Is there any need for an executive session? Hearing none, I would entertain a motion to adjourn.
So moved.
Do I have a second?
Second.
Call the quick roll, please.
Commissioner Hausman,
Aye.
Commissioner Metzger,
Aye.
Commissioner Young,
Aye.
and Chair Elliott.
Aye. Well, thank everyone for attending today.
Okay. Wayne, I'll give you a call in a few minutes, see about signing the plats.
All right. I hope we didn't scare you away, David.
You look like a rough bunch, but I think I'll make it through.
Well, the worst one wasn't here today. Darren's the worst to get along with.
I've got this ultimate mute button over here. I can mute. I'll get control here. We'll turn people off.
Okay, you all have a good one. I'll see y'all soon.
Okay.